Okay. All right. Well, thanks for showing up. All right. This is a good day because this is the last time you'll get notes from me, unless, again, if you take another class like world history in the future. All right. So hopefully everybody can see this. It's not too much of a glare. Like I said, Judicial Branch, this chapter is going to be pretty short. So this is the last thing of notes for this. So what I'm going to do tomorrow is I'm going to send out the Constitution test, but you'll have until Sunday night to turn it in. All right. But don't wait till the last possible minute. Again, you can use all your notes. You can use the internet if you need to as well. All right. So, but make sure you get it turned in because you got to have the Constitution test to pass the class. All right. So I have to have that. I have to have that in from you guys. All right. So let me kind of get at this here. So yesterday we were talking about, and again, it's basically me talking, you trying to stay awake, but I want to keep you in part of the experience. So we're talking about the Supreme Court, which is the highest court of the land, the Judicial Branch. With the federal court system, it's basically kind of placed into tiers, if you will. All right. So what you have is you generally have 3 levels of the federal court system, and so what there's a kind of definition here for each of these court systems. You have what we call jurisdiction, which is basically who gets to see it.
Can you present yourself?
Can I present? You can't. Can you not see?
I can kind of see, but some of the words are cut off and stuff. So.
Okay, let me see here because I got a video in here I'm trying to show. Can you see that?
Yeah.
Okay. I just needed to angle it a little bit better. So, like I said, below the Supreme Court, there are other federal courts and it doesn't rarely does a case go straight to the Supreme Court, obviously. And the Supreme Court just had there was a case that was brought in front of the Supreme Court that was kind of fast tracked there pertaining to the election. All right, but normally these cases if they make it to the Supreme Court, they have to go through the other federal court systems. So there's those. Each court has what we call jurisdiction. All right, you guys got this? Can you see? All right, click there. Okay, so what I'm going to do here, I'm going to play this video here, which I know these are kind of corny, but they do a great job at kind of like breaking stuff down, kind of explaining here. So what we're going to kind of talk about. Oops, go back there, Alex. Me.
Okay. How do I go back?
I got you. Sorry. Okay.
Hi, I'm Craig, and this is Crash Course Government and Politics. As fans of our series know, here at Crash Course, we believe in hierarchy. First at the top, you got me. And then there's John Green, then Stan, then Brandon, then Zalea, then a bunch of independent contractors. Wait, I'm an independent contractor. Well, I'm still at the top. Anyway, then the rest of it's turtles all the way down. That's at the bottom. There's an eagle. Anyway, it's the strict adherence to hierarchy that makes CCHQ run like a well-oiled machine. The same can be said for the U.S. court system. As you probably remember, because you're a smart rememberer of things, the American court system is hierarchical, which means any discussion of it cries out for a visual representation. Thought bubble, like Drake, will start from the bottom. The trial courts have original jurisdiction. When you realize that there are 50 states, each with its own court system, it shouldn't be surprised that the vast majority of cases start out in state courts. Of course, most cases never get to court at all. The vast majority of disputes, criminal and civil, are settled outside of court. How is that for efficiency? On the federal side, the trial courts are the U.S. district courts. There are 94 of them with 663 judges, more or less. Sometimes in civil cases, a plaintiff, the person bringing the case, will have a choice about whether to bring that case in state or federal court. But you can only start in the district courts if your case meets certain important criteria. Almost all criminal cases start in state courts. So if you don't like the result in the trial court, and you have a reasonable claim that there was something procedurally wrong with the case or the way the law was applied, you can bring an appeal. Notice that if you start in state courts, you usually have more chances for appeal because most states have 2 levels of appellate courts, and the federal system has won. Appeals courts can refuse to hear appeals, and if they do, you're done. One thing to remember, the loser can always try to appeal, even if that loser was the state that failed in its prosecution. Federal appeals courts are called circuit courts, and there are 12 of them, distributed regionally throughout the U.S. You might guess if the region where your case is heard matters, and you'd be right. Judges in the Ninth Circuit, which includes California and Oregon, tend to be more liberal than judges in the Fifth Circuit. Federal appeals are usually heard by panels of 3 judges, while trials in the district court are before a single judge. There are 4 scenarios where the federal courts have original jurisdiction, and in all cases, they must be brought in a district court. They are cases where the law at issue is a federal law, like a claim against Obamacare. Cases involving treaties, which are by definition federal laws. These are pretty rare and really interesting. Cases involving the U.S. Constitution, for example, a case concerning freedom of religion. And cases where the U.S. government is a party to the litigation. The other type of case that can go into federal court is one involving more than one state where there's more than $70,000 at issue. This makes sense because if the parties in dispute are in different states, they might not even agree where to have the trial, and federal judges are supposed to be more impartial than state judges. Thanks, Thought Bubble. So thoughtful. So bubbly. If you read the news and pay attention to legal cases, most of what you see are lower court decisions, at least until the spring when the Supreme Court starts handing down decisions. These are the ones that tend to make it into the history books and that you may have even heard of. But how does a case get to the Supreme Court, Craig? Well, I will answer that for you. That's my job. Most of the time, the Supreme Court has appellate jurisdiction. In fact, it's the final court of appeals. If you lose there, you really lost. When the court hears a case, it's called judicial review. There are, however, circumstances when the Supreme Court has original jurisdiction and can act like a trial court. So it's a good thing that most of the justices are, in fact, lawyers, although there's no constitutional requirement that they need to be. The court has original jurisdiction in cases between the U.S. and a state, cases between 2 or more states, cases involving foreign ministers or ambassadors, and cases brought by citizens of one state against citizens of another state or against a foreign country. What do these cases have in common? The main thing is that you can't imagine there being a single state where they could happen. This is especially true in cases involving foreign officials. And then there are my favorite Supreme Court cases, crimes committed on the high seas. That's right, the Supreme Court can exercise original jurisdiction over pirates. This is not as weird as it sounds because crimes on the high seas, by definition, have not happened in any state. So where are you going to have the trial? But most of the time, cases that make it to the Supreme Court are there on appeal. In order for the court to exercise its appellate jurisdiction, the case must raise a federal question. For example, one involving due process or equal protection or an important federal statute. If you don't know what those terms mean, don't worry. We'll get to them. Here's the thing, though. The Supreme Court doesn't hear a lot of cases. It doesn't want to. And I don't want to either. I understand. They also can't. And it's not just because most of the justices are kind of old. It's because there are only 9 of them, and they get requests to review about 8,000 cases a year. Out of these, they actually hand down about 80 decisions. So they have decision rules to weed out the cases that they don't want to hear. The first one is that there has to be a case or controversy, which means that you can't request the court to review whether or not a law is unconstitutional before it has gone into effect. There has to be an actual injury first. Another way of saying this is that the Supreme Court will not issue advisory opinions speculating on whether or not a law might violate the Constitution. The second hurdle a potential Supreme Court litigant has to get over is called standing. Oh, that sounds terrible. I wouldn't want to be standing. No, this means that in order to bring a case, the parties must have a substantial stake in the outcome, which usually means an actual injury. Lack of standing is one reason that the court has refused cases about same-sex marriage brought by opposite-sex married people. The court will also refuse to hear a case that is moot. Mootness, which is a real word, I promise, I'm reading it on the teleprompter, means that the case no longer requires a resolution, say because one of the parties is dead. The flip side of mootness is ripeness. If a potential injury has yet to occur, the case is not ripe. It's like a hard avocado. Your guacamole, not going to be very good. It's best not to be too anxious about bringing your case. Most of the time you can wait, except in cases like Bush v. Gore, where we kind of needed an outcome so a new president could move into the White House. There's also a vague decision rule called the political question doctrine. In some cases, the court would rather that the executive or legislative branch handle the issue and not get involved. There are certain cases that the court will almost always take, even though all things being equal, they'd rather not. When the circuit courts have reached different or conflicting conclusions on the same issue, what's known as a circuit split, the court will usually hear the case to resolve the confusion. The court will also almost always hear a case where the federal government itself initiated the appeal. Finally, the Supreme Court will usually take a case that has a clear constitutional question, like one involving freedom of speech or religion, although there are sometimes constitutional issues that they feel are settled or they just don't want to deal with. For a long time, for example, the court didn't hear gun control cases, and nowadays they don't usually take obscenity cases. Okay, so that's the structure of the court system and how a case does, or usually doesn't, make it to the Supreme Court. What we haven't really discussed is what happens when a case does make it to the Supreme Court. We'll show you that next time when we take a shortcut to the Supreme Court by...
Okay, all right, so we'll kind of skip through there. So like I said, right below the Supreme Court, what we call district courts. Back it up here. Hold on. Yeah, hold on. Sorry about that. All right. So these oftentimes, like I said, the Supreme Court doesn't oftentimes serve as a trial court. They're mainly dealing with kind of constitutionality of things. So usually cases that go to the Supreme Court, not always, but if they're a federal law, dealing with federal law, start in the district courts. All right. And so this is what we're talking about in the video there. It's talking about original jurisdiction. Who has the right to hear a case first, basically. All right. And so the country is kind of broken up into kind of regions, district court regions. There's a district court over in St. Louis. So again, these kind of serve as a kind of traditional kind of trial courts when it pertains to federal law. Now, if we would have had time, we would have been talking about state courts and stuff like that. But due to time restraints, we're not going to be able to get to that. So let me kind of keep it moving. And then the second level, a lot of times if a case is heard at the district level and the parties involved do not necessarily agree with the outcome, they have the right to appeal. So the second level is what we call the Court of Appeals, what we call appellate jurisdiction. These just basically determine whether the case before in the district court, whether that case met the requirements for what we call due process, and we had talked about before, which was basically guaranteed in Fifth and Sixth Amendments. And they just, and again, it's not retrying the case per se. It's basically making sure that or if any like new evidence is brought forth, or if people were kind of denied certain procedures. You guys got that? I'm gonna keep it moving here. Yeah, you got that. So these are the regions here where we kind of have the district and Court of Appeals. I don't know if you can see here where St. Louis is in what we call the Eastern District, the 8th district. It's in the Eastern region there. Illinois is probably, if any kind of federal court cases would be handled in Chicago in the 7th district. And like the video said, a lot of cases times these are, you'll find regions where they may come to a different decision. And so certain cases, if, like I said, in the 9th district tends to have more liberal judges, districts like the 6th and the 11th district tend to be a little bit more conservative. The 8th district tends to falls a little bit more centrist, but a little bit more on the conservative side. So a lot of times cases are brought to certain district courts and Court of Appeals, maybe not necessarily based on geography, but based on how they feel that they can get a case through, whether they can get a decision made based on kind of a certain ideology. So a lot of times you'll hear things on like, a federal court ruled that a certain law was unconstitutional. And then another region may have the same law and they may determine it constitutional. A lot of times that's when that kind of heads to the Supreme Court. All right. And then this is the federal court building in St. Louis. I don't know if you've ever seen that there if you're driving over St. Louis. Matter of fact, a friend of mine actually kind of handles all the IT stuff there. And the court dockets and stuff like that. So that's a building that you may be familiar with if you drive over St. Louis. So types of law, and within this chapter to kind of talk about, and these a lot of times kind of transcend kind of federal state laws as well. So we have criminal law, which is probably one thing most people are kind of familiar with. Again, when it says define acts of crime, here's a definition of crime, all right, which is, again, if we would have had the test on this chapter, you would have had that in the word bank. That's your kind of standard textbook definition of that. So again, in district, crimes like federal crimes. Sometimes you'll have certain cases that you can have a crime in both federal and state law, state courts. So there can be a little bit of crossover with that. All right, and then you have the other type of law, civil law. So criminal and civil law. Civil law, basically, these are disputes. Usually people are arguing when somebody sues somebody, usually contracts, disputes, like it says, their divorce proceedings, property boundaries and stuff. Again, you have federal and state. A lot of civil law cases, though, that kind of tend to go to court usually start out in states, courts. because states are usually the ones who kind of oversee things like contracts, like divorces and things dealing pertaining usually with businesses. Okay, there you go. And then you have statutory law. There's your sources of laws here. Where are these kind of like where these laws originate and come from? Statutory is basically a law passed by a legislative branch, Congress, state assemblies. You have local governments. So you have city, state, federal. These are often referred to as statutes. So they call statutory law. So any law passed by government. Federally, probably the last thing that, when you talk about, like they mentioned Obamacare, or the Affordable Care Act, that is something that tends to be brought in front of the various district courts on a federal level. And then you have common law, which these are laws that are based on what we call precedent. Precedent is essentially earlier decisions made by kind of lower courts. In certain cases, like a lot of Supreme Court cases, the justices will look at the previous cases that came before to try to help make a decision. Precedent isn't always the major factor on making a decision. There are certain laws that, in certain cases, as time goes on, get overturned. But a lot of this that's why a lot of these judges have clerks to kind of maintain certain laws, maintain what we say on the books. A lot of that is based on precedent. And then you have administrative law, laws that are made by government agencies that we had talked about, like kind of like if you have certain laws, like we were talking about, like with the EPA, there's certain laws that were passed that we call kind of like regulations pertaining when it comes to pollution and stuff like that. And then the ultimate one, in which like a lot of the federal court systems, especially the Supreme Court, decides on, we call constitutional law. A lot of this deals with things like freedom of speech, freedom of religion, like with the aspect of like kind of school prayer, right to protest, stuff like that. So that there is chapter 7 in a nutshell. All right. So I'm going to send out tomorrow morning. I'm going to send out the Constitution test. Like I said, you guys got about 4 days to work on it. I'm not going to have a Google Meet. All right. Whenever you get done with it, just submit it back to me. Now, if you happen not to pass, I'm going to probably have to send it back to you guys. All right. You get 2 opportunities to try to pass, but I would expect with the kind of amount of time that you guys got and the ability to use your notes as well as the internet, you should be able to pass. Does that sound good? Somebody? Anybody?
Sounds good.
Oh, thank you. Thanks, Cohen. All right. Okay, guys. All right. Well, on a Monday, next Monday, I'm going to send out just kind of a packet on the Illinois state government stuff. All right. And that will basically cover our Illinois state requirement. You got to get that done though, and turn it in so I can give you the Illinois state constitution as passed. Okay. Hold on, Caleb. I'll move back there. Right there. All right. All right. And I also have this recorded. So if you want to go back and relive the experience, you're more than welcome to. So I'll post that a little bit later. All right, guys. I'm going to sign off here. So good luck. This is probably and also to those of you guys who need to turn in work, continue to turn in work. I will be accepting late work.